This case arises from a quite shameful period when good Australians with German, Japanese, or Italian blood were placed in internment camps for the Second World War because they might be sympathetic to those enemy nations. Tardiani and two other Italian men were interned, but they were released to work as woodcutters for Steele, who exploited them badly. He agreed to pay the Italian men a certain price if they felled wood and then cut it into lengths 6 feet long, 6 inches wide. The court found that the Italian men had cut a lot more wood than they were paid for. In fact, they weren't paid anything at all for many months. The court also found that while they had split much of the firewood to the required length and width, some was too long or too thick. Steele argued that the rule in Cutter and Powell governed this contract. That rule says that unless you fully complete your side of the contract, you can't demand that the other side complete their side of the contract. So, he said, they didn't cut all of the wood to the right size, so they can't claim payment. Reading the judgment, it's clear that the court thought this was a tricky and exploitative position to take. Justice Dixon led the charge in response. He said that this contract was divisible. That is, it could easily be divided up into many, many small obligations. In such a case, rather than applying the rule in Cutter and Powell to create injustice, the court would do better to consider each of those small obligations and to require payment for the obligations which had been met. Justice Dixon said the contract made by the 3 released Italians in the present case is infinitely divisible, but only those billets or sticks can be counted which qualify by substantial or reasonable compliance with the specifications. In this sense, the terms of remuneration are entire, or in other words, each divisible application of the contract is entire and is only satisfied by performance not partial but substantially complete. In other words, when a contract is divisible, the court is free to divide the contract into much smaller obligations and then to ask whether each of those smaller obligations has been completely met. In this way, we have a balanced, sensible alternative to the rule in Cutter and Powell.